Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Good afternoon and welcome to the Southwest Florida Real Estate Update. I'm Michael York with the York Real Estate Group, and I'm joined today by our host Jim York and his guest Don Ross of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Don, we have on the show again for our legal tip for the month. For the viewers that have not really seen the show, could you just give us a little background about yourself and your company that you have?
I'm an attorney. I've been a member of the bar since 1983. I have a degree in taxation. My focus is on real estate. I'm the owner of Ross Title and Escrow. We've got 8 closers. We've been doing this for quite a while, do a significant volume. I'm a shareholder in the law firm Ross Lanier and Dyfick, and I'm a shareholder in Downing Fry Realty, Inc. Been their attorney for 25 or so years. So been doing real estate matters for quite a long time.
In your location, and tell us a little bit about your team also, where you look.
My location is the corner of 6th Avenue North and 41. We're on the west side. It's the Capital Bank building. I feel like I'm plugging this place, but it's right across the street from Pastrami Dan's. Most men seem to know where that is. My team, my office manager, Janet, who was the employee of the month last month, she's going to hate that photo, by the way, has been with me 28 years. I have her daughter, who's been with me 18 years. I've got her sister, which I'm losing track of how long she's worked for me, and her daughter, as well as 4 other people. All have been with me for quite a long time. And I have my wife's cousin, so I'm covered every way you can possibly imagine.
I know we've done a lot of business with you, and it's just been a pleasure to do
Appreciate
business
it
with
so
you.
much, I really do.
Well, you know, today is a little bit different. We're going to do a little bit different show, because I have a lot of questions that people write in on.
Great,
okay?
that sounds good.
Some of them I think make sense, or some of them might be a little bit
Some
different than what we're used to. But what I want to do is, the first question a person asked is that they did a contract, wrote a contract, and then they developed an illness that maybe they couldn't follow through with the contract.
Right.
What, you know, how would can they get out of the contract? What would they need to do?
Well, they would need to call me or whoever's representing them. The contract, and I have it here, you know, the actual last sentence to this contract is that the contract shall be binding upon and in order to the benefit of the parties hereto, their heirs, administrators, personal representatives, and successors and interests, which means their kids, their family, whoever inherits. So it is binding on somebody who is sick, okay, legally.
Legally.
In the real world, since this is a Naples Board of Realtors contract, I have on occasion had the misfortune of having to notify a seller that my client has cancer.
Right. And
out of simple humanity, the seller would release them from the contract. I mean, nobody wants to suffer through that horror of an illness. People do have hearts. I mean, they really do. So if you're just totally straight and honest on what's going on, you're more apt to get a positive result. So there's the legal answer, then there's the real world answer. I have had people walk away from the deposits. I mean, again, with a NABOR contract, the most the buyer would lose if you run into you know, Scrooge for a seller, and they're not willing to let somebody out because they're potentially dying, you know, God forbid. The most the buyer would legally lose would be the actual deposit made. We've got that FAR contract where they can go after deposits made or agreed to be made, but I've never seen somebody chase somebody who's really seriously ill. People generally develop hearts, at least so far. It seems like our society is going down the hill here, but so far they tend to develop hearts.
Now the next question, we've gone over this in one of our other shows, but next question was the people, how I phrase this, is that they purchased a place with a contract and it was furnished,
Right.
It was completely furnished, okay? In that there's the discrepancy what was included and what was not included. So when a person is purchasing a property from a realtor or even the seller, what would be the best way of listing the furniture or making sure what is going with it, that there's not a question after the fact that they took maybe something out that they thought was included?
Well, in interests of full disclosure, that's not on our list
It
here.
isn't.
Son of a gun.
Well, I
but-
couldn't, you're right.
Thank you so much, Jim. Okay, so so the way you handle that, and
That came in at the last minute, that question.
you having a spontaneous thought.
That's
Huh?
right.
Just what's the best way to describe furniture? I was at a meeting this morning and I was asked that question, and what I told the agents in this case was you want to start with the shortest list, the things that are being conveyed
Right.
or the things that are being excluded.
Mm-hmm.
If you can do a perfect list,
Right.
wonderful. But in the real world, again, Saturday your buyer's making an offer, the seller needs to respond. Who's going to sit there and count every widget in the house, how many spoons there are, and itemize with great detail
Right.
all the personal property. People don't want to do any more work than they have to. So what I tell the agents and now the public is you want to be as clear as possible. You want clear communication, because most conflicts and end up in litigation are because of lack of communication. And so go with a short list. If you're giving the buyer everything except 6 things, say turnkey furnished minus, and then have a list of the 6 things you're excluding. If you're only conveying 6 things, the table, the 4 chairs, a couch, I'm up to 5, and a TV, 6, make a list of that.
Okay.
You want to be clear. And the other point I made was take pictures of everything.
That's right.
And I mean, we all have, I got my phone, it is
Right.
off this time, thank goodness. Take pictures, because there's a provision in the contract that if something breaks, there is damaged before closing, that the seller is liable, and especially like the yard. If we
Right.
have a hurricane or something like that, the seller is responsible for the landscaping. So you want photos of these very expensive palm trees and so forth that you have out in the yard. And you want photos of everything in the house, because I have had the misfortune of experienced people who switch light fixtures and furniture, and even I think I have one with your son where they might have changed beds.
That's right.
So
You're right.
the photos, you can see the difference in heights
height.
of the beds, and you hate to plan for the worst in people, but plan for the worst and hope for the best.
The next question here, does a Florida landlord in a tenant status prevail over a written lease?
Depends what it is. There are certain things that are public policy, and it's not just the Landlord-Tenant Act, but it's the homestead law. It's a lot of different things. The Landlord-Tenant Act, Chapter 83, requires 3 days notice, for example, if the tenant has failed to make a rent payment before, 3 days notice delivered to the tenant before the landlord can file for eviction.
Right.
Okay, now the lease can give the tenant more than 3 days, so it can be more generous than what's in this statute.
Right.
But the lease cannot be less generous. You can't waive it. You can't say you don't have to do the 3-day notice. Okay. You don't have to notify the tenant where the security deposit is being held. You can't do that.
Right.
But you could get, or if the Landlord-Tenant Act gives the landlord a certain period of time to make the claim on a deposit. It's 30 days. The lease could say, well, we're going to limit that. The Landlord-Tenant Act is really designed to protect the tenants. I hate to say it, not the owners per se. I mean, it protects the owners somewhat in that there's clarity on who's responsible for what, but you can change who's maintaining what. You can give the tenant a longer time period to cure a monetary default. more time to cure a non-monetary default. They didn't cut the grass, and
That's
so they're in
right.
default to the lease. You can be more generous, but you can't be less.
Okay. Well, Don, before we go to our next question, we're going to take a little short
Sure.
break, and we're going to be back in 1 minute. Thank you.
Okay.
When picking a realtor, don't just pick anyone. Pick someone with experience. Pick someone with a proven track record. Pick a realtor like Jim York from Downing Fry Realty, the #1 brokerage with the most real estate transactions in the area.
My husband and I had very specific ideas about what we wanted in our new home. Jim York was able to help us find the home that was ideal for us.
With over 20 years of real estate experience in Southwest Florida, Jim York has negotiated over $200 million in sales contracts. Selecting the right realtor is a critical decision that can earn you thousands when selling or save you thousands when buying.
Jim also helped us with a mortgage lender and a good real estate attorney. He went that extra mile, and his experience says it all.
Call Jim York for a no-obligation meeting at 239-273-6727 or visit his website, www.naplesyorkrealestate.com.
Welcome back. Don, the next question here I have, the appraisal came in lower than what the builder wants. They refused to lower the price. Would they be entitled to their deposit being returned?
This is, again, a real live question from somebody who emailed you.
That's right. I just
Depends,
took
it
it by
depends
what
on
they
the
said.
contract. I mean, I've read so many developer contracts, and I'm presuming this is a developer contract. I've seen some that if the buyer defaults, their damages are limited to some nominal dollar amount. It's not more than a certain percentage. I have not seen any, frankly, where the developer is required to return their deposit in full. Never seen that. In fact, there's usually something in these developer contracts that allow them to get appraisals, but say that that's you know, they're not held to that. That's not indicative of what they're willing to sell the property for. So they go out of their way to point out in most developer contracts that you can go get your appraisal, you can go apply for a loan, but the price is the price.
Right.
So then again, by default, I'll go to the default clause, and if it's some nominal amount like $1,000, that's all they're going to lose, and it's a deal breaker for the buyer. I say, well, that's your cost for getting out.
Right. That's why they should call you first, right? And
Or-
read the
or you.
contract over, I mean.
Absolutely.
Right, read the
Absolutely.
contract
Well,
over.
that was our last show. Sure.
Here's our next question. Two parties submitted best and final offer for the seller, okay? Both offers came exact, earnest, and closing, right?
Yeah.
Can they ask the buyers to increase the offers? So-
Sure. This is something, again, as the attorney for Downing Fry, I write little articles, and this comes up a lot in my practice, and this is actually covered by the National Association Realtors Manual Ethics and Arbitration. They have, I think it's 3 or 4 pages that discuss this exactly. And what I tell agents and clients is that you tell both parties, you know, there's multiple offers.
Right.
Make your best offer. I'll make a decision by 5 o'clock tomorrow.
That's right. I've done that before too. Right.
You don't have to tell them how much it is.
Right.
Just make your best offer. You know, and in fact, if you're the listing agent, you're in my mind. I mean, if I
Right.
listed my home with you,
Right.
which I'd have to get past my dad before I did that.
That's right.
If I listed my home with you, I would want you to, start a bidding war
That's
for
right.
my house, get the best price.
Right.
So, and you have a legal obligation, not only an ethical obligation, but a legal obligation to submit all responses, and even after the contract is fully executed, whichever one the owner goes with, if you get other offers, you're obligated to submit those too, because that can affect what the owner would do if the buyer is asking for repairs, or if the owner is trying to decide to terminate a contract under the financing contingency clause if we're past our 45 days. And the owner's getting antsy that the buyer hasn't waived the financing contingency. If he knew that
Right.
Jim York had another offer on the property,
Right.
that would have an impact on the decision. So the case law requires you to submit all offers,
Right.
regardless of when you get them.
Okay, okay. The next question here, neighbor refuses to remove bees from wall of a house. What can they do? My dog has been stung and my kids have also.
Boy, this one bothered me the most. Well, I mean, here we are on television. Do I tell them what I would really do, or? I mean, we've had the misfortune of having our dog, my wife and my dog, attacked by another dog. So, I've sort of lived through this. Number one, I try to look beyond the law and what is really best for my client. You have to live with these people next door. You don't want to file a lawsuit or even necessarily report them to the county for a dangerous situation. I mean, you don't want to be pulling into your driveway at the end of a hard day working and having somebody giving you the stink eye from next door. You want to be friends, for crying out loud. So what I would recommend here would be, get a price. I mean, how much money are we talking about? I mean, are you dealing with a neighbor who thinks it's not a big deal, and you might have a child who has an allergy to bees, or grandchildren? I mean, I have grandchildren. I think at least one of my kids is allergic to bees. Is it a huge hive? And I've had that too, where you could potentially throw somebody into anaphylactic shock.
That's right, you can.
I mean, we have that in my yard. I mean, so it can be a scary situation. So in interest of safety, in interest of being a good neighbor, how would you want to be treated in the same situation? Get a price. Is it $200? You knock on the neighbor's door and say, I will pay for it. If, you don't know, maybe they have financial issues. Right. They're having trouble with, maybe somebody's sick in their family. Maybe they think you're just crazy for worrying about 3 bees on the side of the house. But offer to
take care of it.
Take care of it.
Right.
I mean,
that's a good idea.
Legally, you can file a complaint.
Right.
Practically, I think you're crazy not to explore these other options.
Right. Well, Don, we're going to take another little short break, and we're going to be back 1 minute, and we'll finish up some of our questions from our viewers. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Don, one question here. It says, can a bank get a quitclaim deed and there be no notification to me being foreclosed?
Just like you, I have a team, and I called my partner Celia Dyfik, who does foreclosure defense. Lucky me, I happen to know somebody who does this. As a practical matter, it's a quitclaim has to come from the owner of the property.
Right.
That's a deed. The only one who could sign a deed is the person who owns it.
That's right.
So there is a process where if somebody's being foreclosed, they can negotiate, and Celia does this, a deed to the bank in lieu of foreclosure. And it actually gets complicated because you have to worry about forgiveness of indebtedness if there's a deficiency. When we had all those short sales going on a few years ago, so you need to check with your accountant. Do you have losses to offset this gain? I think the statute with the Internal Revenue Code has expired on this, so you got to worry about gain. And you can negotiate a deed in lieu of foreclosure with the bank, and that's something Celia would get involved with. Generally, there is a process. There's my phone again. There is a process where you can serve somebody constructively in a foreclosure action. If the owner of the home has disappeared to Venezuela and you're never going to get them, there is a way to get constructive service on that person and get the foreclosure happening, have a sale on the courthouse steps, getting a personal judgment against the homeowner is theoretically possible, but in 99% of the cases it doesn't happen. It's very hard to achieve that. So as a practical matter, you need personal service to foreclose. The bank is not going to get a quick claim from somebody else other than that person who would be foreclosed. And that would be the deed in lieu of foreclosure. So trying to figure out what the viewer was getting at with this question was a little hard because it was mixing two questions really into one. The quick claim comes from the owner anyway, so there's your notice.
There's your notice. Right
but how does the foreclosure work? 99.9 you get personal service, but if they skip out, there are statutes that govern that.
That's another. The next question: does the title company have the responsibility of ordering the survey on the property?
This question bothered me because I own a title company, and I'm not. I wanted to say I'm not responsible for anything, but I know. We recommend surveys. We've talked about before pushing common mistakes sellers make. I think that was one of our high-rated shows. One of the big mistakes, most common mistakes a seller makes is not looking for their survey. The survey can save that seller a major headache. I personally see a lot of issues come up when the seller can't locate their survey, and it doesn't even bother to get off the couch and look for it, and then the buyer is forced to order one. They're getting a loan, the bank requires it, and surveys might cost $350, so they run in, they run out, and you end up having encroachments.
That's right, yeah.
You end up having encroachments all the time. Like 1 in 5 deals I have encroachments. It's a major pain. Is it my responsibility to order it? Well, the bank's going to tell me to order it if the seller doesn't provide one. We ask the seller to give us a copy of their survey if they have one, and we encourage them. It's to their interests. Because to get a variance, I mean, the filing fee alone is $1,000.
That's right, yeah.
I mean, just, even if it's 2 inches. I mean, I get 2 inches encroachments, and it's $1,000.
I know, I've had ones less than that even.
Yeah.
1 inch, and we thought maybe the machine wasn't even calibrated right. That could be off an inch or whatever.
Well, I mean, the machines are more sophisticated, and they're not using the same monuments to do the measurements from.
Right.
And under the case law, the old monuments prevail over the new monuments. And if somebody's getting paid $350, they're not digging around in the sand looking for the original concrete markers.
Right, yeah.
They're using unnumbered iron rods.
That's right.
And then you get your 1 inch or less
That's
encroachments,
right, yeah.
and the bank wants that fixed, the buyer wants that fixed. They're asking me, Don, is it a problem? And well, if you sell it, somebody else might make it a problem.
Yeah.
So we got to deal with it. It's a very common issue.
The next question here, we hold a note on a home that had a balloon payment that was due on 7/16, or 2016, or 1, it was January.
Right.
It's a little older. What can I do to get my money due that they don't pay?
Well, unfortunately for this viewer, they have to hire an attorney.
That's right.
I hope there's a mortgage along with this promissory note. There probably is.
Filed.
And they're going to hire a lawyer. The lawyer is going to update title to see if there are any other liens against the property. If the homeowner has not been paying their mortgage payments, chances are that they've missed their credit card bills and maybe a few other bills. They might have gotten a second mortgage on the property. So you're going to have to foreclose on all those things in order to get your property back. And again, Celia, my partner, does that. That's her specialty.
Okay, the last question we have here, 8 tenants in common on a real estate. 1 tenant has liens higher than the individual proceeds. Do the others have to pay the lien?
I, honest to God, don't know what this question's talking about. Honestly, if you have any idea what this is.
So I
no,
guess
no offense to whoever asked it.
I know, but I just wrote it from what they wrote in.
Is this 8 actual tenants?
It looks like there's 8 people that own the property, maybe.
Oh, okay.
And that, one person has a lien on it, and so are the other 7 obligated to pay the lien off?
If you have 8 people who own the property and they own it as tenants in common, okay, which in English means that if one of them dies, their 1/8 goes to their heirs, and it doesn't go to the other 7 people. If it's in tenants in common like that, the lien against that one owner will only be as to that particular owner's interest, which is 1/8, which is 12.5% of the net proceeds. And we normally get releases from judgment creditors for things of that sort. If it's husband and wife, so let's say you have 4 couples, you know, now you're up to 25%. So you'll have the 4 couples, you know, husband and wife, which is a joint estate by the entirety, which means if the wife or the husband passes away, the surviving spouse owns that 25%. The lien against the couple will attach to 25% and not to the other 75. I think that was the point of that question, because I was a little confused by it.
Well, Don, I appreciate you coming on the show this month, and
thank you for
I
having
think
me.
we answered some of these questions for the people that
Hope
they can
so.
understand them. But it's
hope
hard
so.
for us to understand some of them too.
Well, they can
So-
send it in again if it wasn't
That's
quite
right.
clear.
Or they can call you too, right?
Absolutely.
So,
Happy to help.
Again, thanks a lot, and we'll see you
Appreciate it,
next
Jim.
week, and thank you.